Viewers, welcome to the Personal Injury Law Show. My name's Tony Carbone, personal injury lawyer with 27 years experience. Next to me I've got John Corrence, he's an accredited law specialist. How are you, John?
Good evening, Tony. Good evening, viewers.
Tell us a bit about accreditation. What's it mean?
Specialist, accredited specialist in personal injury law, Tony. Work cover, transport accident, all the areas of personal injury law.
So you're like a surgeon?
Well, my particular likeness is work cover litigation, as you know, Tony, but, you know, in the end, you have to be a specialist in all areas of personal injury law.
That's it. And next to you I've got Carolyn McGuinness, who's been on the show before. Good evening, Carolyn.
Hello.
You're up and coming in the law.
I thought I was already there, Tony.
No, but work cover. You do a lot of work cover work.
Absolutely.
WorkSafe these days.
WorkSafe, work cover, specialise in that. Litigation.
That's it. Welcome aboard, Carolyn. I really appreciate it.
Thank you.
And
Tony, before we get into work cover and in particular costs, what's in the news?
Look, what's in the news this week is I'm talking about these two guys caught skylarking at work, planking. Do you remember this thing of planking that came up a while ago?
It was a fad, wasn't it?
Yeah, it was a bit of a fad, but it was a crazy fad because there's been people killed.
Yeah.
And these two clowns got caught on Facebook.
What were they doing?
They got up high on this plank. It was on a forklift. And they were planking on top of that.
Disgraceful.
And this was at work, Tony?
At work. And the employer didn't know any of this because obviously no employer would condone this sort of behaviour. But they got caught out on Facebook.
Oh, they uploaded their photos onto Facebook,
yeah,
to show all their friends and...
That's exactly right. And the beauty of it is this, when the employer found out, reported it to WorkSafe, and WorkSafe prosecuted them. They've been fined.
Fantastic.
Albeit they've got no conviction. But it just shows you the stupidity and nonsense. I mean, people are dying on the job all the time, and this is a classic way of getting killed.
I'm glad the Victorian Work Cover Authority has really gone hard here.
So what they've done is they've been sacked, which they should be, and also they've been fined, although they've both gone out there and found alternative jobs. But it just shows you, don't muck around on the work site. It's dangerous. There's dangerous machinery, dangerous tools, and don't make it any more dangerous than what it already is.
It may have been a laugh in that instance, but we all know, Tony,
if they had fallen off the top of this forklift on their head, it wouldn't have been too funny, would it, Carol?
Well, they wouldn't have qualified for work cover either, because it's clearly misconduct.
That's exactly right. That's a very good point.
Yeah.
Would it preclude them from getting no-fault benefits as well?
Oh, absolutely. They'd be on their own, and the employer wouldn't be liable for any of it.
There you go. There's another reason why you should conduct yourselves appropriately at work. All right, let's get on to this topic of work cover costs. In particular, we're talking about costs in the common law jurisdiction. That is, you get injured at work and at some point in time, your injuries are stabilised and you want to lodge a claim for serious injury certificates to obtain pain and suffering, loss of enjoyment of life and also loss of income. Carolyn, give us a bit of background. What do you do to actually lodge one of these claims?
Well, first of all, you've got to have a serious injury, so you have to have an injury arising out of employment. Now, to qualify for serious injury, you have to have what's called a permanent impairment of a body function, and it has to be more than significant or marked, or at least very considerable. And you can claim for two types of damages, for pain and suffering and pecuniary loss. And pecuniary loss is where you have to be compensated for the loss of earnings that you otherwise would have received had you not been injured. And also pain and suffering. And viewers would accept that, would know clearly that pecuniary loss damages would be very significant.
So it's loss of income we're talking about now?
That's right, and can go up to age 60 or 65.
So we're talking about workers that have been injured in the course of their employment.
Correct.
They seek lump sum compensation, as we said,
in circumstances where they say the employer or a third party are at fault.
Exactly, where there's fault attributable to someone else apart from themselves.
That's
John,
right.
The amendments that have gone through as of October last year are very significant.
Yes.
Because there's significant cost implications that arise from these. John, in short, and then we'll get into greater detail, what does this all mean for the worker?
As of any serious injury application that's been lodged after the 28th of October 2010 with the Victorian Work Cover Authority, you, the worker, and the lawyer that's acting on behalf of the worker must get the application right from the beginning, as in whether to make a claim for pain and suffering only or pain and suffering and economic loss. If you get it wrong, as in you've made a claim for pain and suffering and economic loss, but the court or work cover only give you a certificate for pain and suffering only and not for economic loss, then the worker will be severely disadvantaged and basically punished cost-wise, Tony.
Carolyn, would it surprise you that costs, you probably lose about 90% of your fee costs if you don't get it right?
Oh, absolutely, because if you go to court, there's a lot of time and money spent on your file by your solicitors. If you, in fact, what I might do is just run through quickly. If you put in a claim for both heads of damages, pain and suffering and pecuniary loss, and again, I'll just stress to viewers that pecuniary loss damages would be much more significant in a lot of cases than pain and suffering. If you proceed to court and you lose your claim for pecuniary loss, your party costs would only be anything between $2,500 and $9,000. Yet the costs borne by your solicitors to run your file and to win it would be far in excess of that.
Well, Carolyn, let me say this to you. If you go to court and you don't get loss of income, in addition to pain and suffering if you've claimed both,
yes,
costs come back to about $2,400 and something.
$496, Tony.
Now, by the time you've run a case to court, let's say it's gone 3 days, I'd be hesitant to guess costs would be around $60,000 to $70,000. Is that a fair assessment, John?
My estimate, and I think you agree, Tony, that each day in the County Court of Victoria will cost the plaintiff $20,000 in legal costs.
There you go. So my figure's pretty accurate.
Now, the worker gets punished, Tony, don't they?
So, well, this is punishing the worker because what the viewers might not know is that prior to this amendment, any claim for serious injury under the work cover system had a 20% reduction on fees in any event. That's always been there.
And that continues.
That's exactly right.
So not only do we have a reduction in the cost scale, party costs, we've still got the 20% reduction on top of that.
That's exactly right.
So the worker's copping a double whammy, Tony.
Well, a 20% reduction means that the cost is passed from one party to the other party, which is the injured person. So it's very significant. It's really tragic.
Well, that's where the issue lies, as in there could be then an issue with the solicitor-client costs, wouldn't there, Tony?
Oh, look, if it's just a pain and suffering claim, Carolyn, and you've gone 3 days, what's a client going to get? Let's say it's a nasty leg injury.
Well, if it's nasty leg, it depends on if there's surgery. But
let's say you get $150,000.
Just say $150,000.
Yeah.
Out of that comes out of your solicitor-client, but also the shortfall, arguably, of the party that you can recoup. So, for example...
You might only see $50,000.
Exactly.
So it's a total disaster.
Yes, I agree, Tony.
Look, we're going to have to go to a sponsors break, so we'll do that, and we'll come back after the break. So viewers, please don't go away. We'll be back very shortly. Thank you.